Senate Committee on Criminal Justice will come to order. The clerk will call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles,
Present.
Senator King, Senator Hagenbu,
Here.
So a quorum is present. As members is here, we have a new clerk, committee clerk. This is Haley Plumley, and she will be working with us. And
I didn't
Make-
notice somebody different. Spence was sitting next to me.
yeah, I think she'll keep us in line. So folks, thank you all for being here. Members will be coming in and out. There's a lot of committees at the same time, which it's that time of the year. But we intend to address these bills. The purpose of today's hearing is to take up and consider items related to organized retail theft, organized financial crimes, mail theft, forgery, and bank fraud. So we're faced with a scourge of organized thefts by criminal gangs and cartels that's costing Texas businesses and our citizens hundreds of millions of dollars, an untold loss of state revenue. Lieutenant Governor Dan Patrick asked our committee during the interim to find solutions to curb this increased criminal activity. The result of our study, including public hearings and extensive research by the senators and their staff, are the bills that you're going to be hearing that we laid out before the committee this morning. These bills offer tough new laws to crack down on an epidemic of theft involving organized retail crime by criminal gangs and cartels, sophisticated electronic financial scams targeting businesses and average Texans, so-called skimmers that steal credit card information at the gas pumps and in stores, and organized theft rings stealing checks from mail and overnight deliveries. These measures will give new enforcement teeth to our Financial Crimes Investigation Center that has been highly successful at targeting sophisticated financial crimes and scams, and will amp up civil asset forfeiture of digital currency and other property from these criminals, among other things. So our intent is to hit the thieves very hard, very hard. They need to be addressed in our criminal justice system appropriately and not free on our streets, victimizing more Texans every day. So we have consulted with prosecutors who handle these types of cases routinely, some of which you will hear from today, and who were instrumental in drafting this legislation to provide tools that they need to address this situation that Texas is faced with. So I would like to thank Lieutenant Governor Patrick and other members of this committee and the Senate for their hard work on this package of Texas tough legislation. So it is our intent of the chair to lay out the bills one at a time, take invited public testimony, then vote on each bill in order of presentation. If we have a quorum present, and if we don't, we'll pen them and then vote them out as soon as we have a quorum. Will that be all right, members? So with that, we will start with our esteemed Chairman Nichols to explain his bill, SB 1497.
You ready for me to go?
Yes, sir.
All right. Thank you, Mr. Chairman and members. Senate Bill 1497 pertains to skimmers, which are devices manufactured for the sole purpose of stealing payment card information from fuel pumps, ATMs, and point-of-sale terminals. However, a current ambiguity in statute is preventing law enforcement from acting swiftly to search these devices for victim information. Current law requires a search warrant for a cellular telephone or other wireless communication device. However, wireless communication device is not defined. The lack of a definition creates a gray area regarding skimmers and leave this language subject to interpretation. This bill would simply clarify that a wireless communication device does not include skimmers, and I do have a committee substitute.
Chair recognizes committee substitute for Senate Bill 1497. Is there any objection to the adoption of this committee substitute? Hearing none, is adopted.
You want me to explain the difference? Okay.
Yes,
The
please
difference
explain the
between the committee substitute, it expands the exemption to all such devices also manufactured for the purpose of illicitly obtaining payment card information, whether they're actually defined as skimmers by the industry or not. Adding this language will remove the ambiguity, reduce potential harm to victims, and streamline the investigation. That's the bill and the committee substitute.
Thank you, Senator Nichols. Members, are there any questions?
We do have some witnesses.
So invited testimony on committee substitute Senate Bill 1497 is now open. The chair calls Jeff Headley, Texas Financial Crimes Intelligence Center. Thank you for being here.
Thank you very much for having me, Chairman.
Just state your name and your testimony.
Mr. Chairman, Senators, good morning. My name is Jeff Headley. I'm the Field Operations Captain for the Texas Financial Crimes Intelligence Center. I apologize that my director, Adam Colby, was not able to be present this morning, as last minute he lost his best friend in life at the end of last week. Therefore, he is at the funeral today, presenting there in honor of his good friend. But it is my pleasure to be here myself as a last-minute stand-in and somebody who is the guy beating the streets and taking down many of the suspects we're speaking about today. I'm here to address Senate Bill 1497, a one-sentence amendment to Article 18.0215 of the Code of Criminal Procedure titled Access to Cellular Telephone or Other Wireless Communication Device. Article 18 requires a search warrant to access cellular phones or other wireless devices, but it leaves other wireless communication device undefined, creating ambiguity. Senate Bill 1497 resolves this by exempting skimmers, devices built solely by criminals to steal payment card and personal identifying information from magnetic stripes. These devices, often found on gas pumps, ATMs, and store terminals, aren't sold legally and can't store personal photos or communications. Their only purpose is theft, costing Texans millions annually in fraud. Federal courts, including the Sixth Court of the United States for Baugh and the Eighth Court of United States versus De Leal, have ruled there's no expectation of privacy in magnetic stripe data. Thus, searching a skimmer without a warrant isn't a Fourth Amendment issue. Yet, without this amendment, law enforcement risk delays or legal challenges when seizing skimmers. Tools designed exclusively for crime, not communication. Senate Bill 1497 clarifies the law, ensuring we can swiftly disrupt criminal networks preying on Texas citizens. It aligns with your mission to enhance public safety and streamline justice. I urge you to support this bill, giving law enforcement a practical tool to combat financial crime without compromising constitutional protections. I appreciate your time and your consideration.
Thank you for coming and testifying on that. Any members, any question? Senator Hinojosa, you recognize.
Thank you, Mr. Chairman. Just a brief comment. I guess having practiced law both as a prosecutor and criminal defense lawyer, I can see where other wireless communications device would be so vague and a huge loophole that I certainly would file a challenge to any confiscation of that device without a proper search warrant. So I guess with the bill that Senator Nichols is carrying, Senate Bill 1497, you really close that loophole to make sure that those devices, which are really not used for communication other than just to commit a crime, are not, it's clear they're not covered and need a warrant. Did I pretty much summarize that?
Yes, Senator Hinojosa, you said it perfectly. This is literally a very specific targeted bill that gives us a clear definition of skimmers, as in the other parts of the Criminal Code Procedure and Penal Code that we've already added in, that will only target these devices which are nefarious in nature and only designed to steal people's payment card information.
Thank you, Mr. Chairman.
Thank you. Any other questions? Thank you. Thank you for your
very much.
testimony. Thank you for coming. Are there any other additional invited witnesses? Seeing none, invited testimony on this bill is now closed. Chair now opens public testimony. Chair calls the following witnesses. Do we have any public? There are none on this bill. So, anybody here to testify publicly on for or against this committee substitute for Senate Bill 1497? Hearing none, public testimony is closed, and since we don't have a quorum, we'll we'll pen this bill and we can move to the next one. Chair recognizes Senator Nichols, Senate Bill 1498.
Thank you, Mr. Chairman. 1498 aims to expand law enforcement's asset forfeiture capabilities to encompass digital assets. Digital currency has become the preferred method for money laundering and is widely used for contraband transactions on the dark web. Additionally, it plays a troubling role in scams that target vulnerable elderly victims who are deceived into depositing their life savings into crypto ATMs. In many of these cases, asset forfeiture represents the most effective means of recovering stolen funds. The bill seeks to establish clear definitions and procedures for the forfeiture of digital currency. That's it.
Members, any questions? No questions, so invited testimony on Senate Bill 1498 is now open. The chair calls Jeff Headley, Texas Financial Crimes Intelligence Center.
Senators, Chairman, thank you once again for having me. Jeff Headley with the captain I'm the captain over the field and operations at the Texas Financial Crimes Intelligence Center. I'm here today to express our strong support of Senate Bill 1498, a bill that would streamline the asset forfeiture of cryptocurrency in a criminal case. The FCIC has witnessed a concerning rise in the use of cryptocurrency in criminal activities, particularly scams targeting vulnerable Texans, including the elderly. The complexities of tracing and seizing cryptocurrency pose significant challenges to law enforcement. Currently, very few agencies possess the specialized expertise and tools required to navigate the intricate process of cryptocurrency seizure. The FCIC is proud to be one of the few state agencies equipped to handle these complex investigations and seizures. The scarcity of expertise underscores the critical need for a change of venue provision as proposed in Senate Bill 1498. By allowing the forfeiture process to occur in the county where the seizing agency is located, we can ensure that these specialized agencies, including the FCIC, can efficiently and effectively carry out the seizure of criminal assets. Furthermore, this bill addresses a significant gap in our current system. At present, many cryptocurrency seizures related to the state and local investigations are being handled by federal agencies. This means that the proceeds of these crimes are often not returned to Texas to benefit our communities. Senate Bill 1498 would empower Texas law enforcement to complete the process, ensuring that the seized funds are used to support the citizens of Texas. The FCIC firmly believes that Senate Bill 1498 is a crucial step in strengthening our fight against financial crimes involving cryptocurrency. We urge you to support this bill and help us protect Texans and their hard-earned assets. Thank you for your time and consideration, and I'm happy to answer any questions you might have.
Any questions, members? No questions. Thank you very much.
Thank you very
for your
much.
thorough presentation. The chair calls Thomas Wilson, Smith County Assistant District Attorney. Is your name and please your testimony?
Yes, good morning, Chairman, Senators. My name is Thomas Wilson. I'm an Assistant Criminal District Attorney in Tyler, Texas, and I am part of the Civil Division of our DA's office. And I am here in support of Senate Bill 1498. This would allow prosecutors with felony jurisdictions in the state of Texas that would give them the necessary tools to combat crimes involving digital currencies. Our office has worked closely with several law enforcement agencies, including our local tag unit, along with the FCIC, to combat these crimes that are occurring involving digital currency in our community and statewide. SB 1498 gives our office the ability to seize cryptocurrency or digital currency that's involved in criminal enterprises that are profited from narcotics trafficking, theft, fraud, and human trafficking, to name a few. Based on previous and ongoing investigations that are currently occurring right now with our tag and our FCIC, we believe that hundreds of millions of dollars of illicit funds are flowing through these crypto markets used from drug trafficking, theft, fraud, and human trafficking. We also know that the victims are local, but the profiteers are not. The profiteers are from multiple different states and even multiple different countries. Currently, there is a gap in Chapter 59 that provides that asset forfeiture is to be filed in the district where the property, either tangible or intangible, is seized. Unfortunately, cryptocurrency does not have a location. It's on a cloud. It's on a server in California. It's on a server in China. It's on a server in Romania. But what we can do is we can seize those funds and place them into our protection. And this gives the DA's office a tool to fight the ever-growing and changing criminal enterprises that are using cryptocurrency as a means to profit off of their criminal activity. So if you have any questions, I'd be more than happy to take those now.
Members, any questions? Any questions? Please, will the clerk show that Senator Huffman is present? And we also have established a quorum. Thank you very much. Thank you for coming. Seeing no other invited witnesses on this bill, invited testimony is now closed. Chair now opens public testimony. The chair that calls Stephanie Mace. So there'll be 2 minutes, and state your name and on for or against the bill, and please proceed. Welcome.
Good morning. Thank you, Chair. Thank you, Senator Nichols. Thank you, Committee. My name is Stephanie Mace. I am Associate State Director with AARP Texas, and I am here for the bill. AARP is the nation's largest nonprofit, nonpartisan organization dedicated to empowering people 50 and older to choose how they live as they age. Throughout Texas, AARP works to empower older adults in the fight against fraud by providing proven resources and tools to help individuals spot and avoid theft and fraud. However, too often, criminals, often impersonating government officials or businesses, convince individuals that they must address an urgent financial matter, directing them to withdraw large amounts of cash and put that money into a crypto kiosk. It is then transferred to a digital wallet controlled by the criminal. This session, AARP is advocating for anti-fraud legislation that will safeguard older Texans from theft via crypto kiosk scams. SB 1498 complements and supports this legislation by allowing law enforcement that are capable of seizing crypto funds to move more quickly, giving them a better chance to recover funds for the victims. Victims are often reluctant to report a financial crime, but if victims know that reporting could help to recover assets that could be used to compensate them or other innocent victims, they may be more willing to speak out. I encourage you to please support SB 1498. Thank you.
Members, any questions? Thank you.
Thank you.
So seeing no other public witnesses on this bill, public testimony is closed. Senator Huffman moves that Senate Bill 1498 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes.
There be 4 ayes and no nays that Senate Bill 1498 would be reported to the full Senate with a favorable recommendation. Do you wish it to go local non-contested, or?
Go ahead and I'll request that, and I'll probably take it to the floor, though.
Well, Senator Nichols requested that the Senate Bill 1498 be referred to local non-contested. Are there any objections? Hearing none, so ordered. We'll move back to the previous bill. And before we go to the next one, if that's okay, your committee substitute. So, members, Chair moves adoption committee substitute to Senate Bill 1497. Is there an objection? Hearing none, the committee substitute is adopted. The chair moves that committee substitute for Senate Bill 1497 do not pass, but that the committee substitute adopted in lieu of their do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
There be 4 ayes and 0 nays. The committee substitute for Senate Bill 1497 is reported favorably to the full Senate.
Also
Do you wish
request
the
local-
same thing?
Yes, sir.
Senator Nichols requests that the committee substitute Senate Bill 1497 be referred to local and uncontested calendar. Is there any objection? Hearing none, so ordered. So Senator Nichols, be Senate Bill 1499. You are recognized.
Thank you, Mr. Chairman and members. Senate Bill 1499 will expand the mission of the Financial Crimes Intelligence Center to include payment fraud, ensuring the agency can continue its critical work in protecting Texans from evolving financial crimes. The Financial Crimes Unit was established in 2021 to combat the growing issue of card skimmers. However, the landscape on financial crime has advanced at an alarming pace, with criminals adopting increasingly sophisticated tactics. As a result, the Financial Crimes Bureau has naturally expanded beyond its initial focus on card skimming to address broader forms of financial fraud, yet the Center's enabling statute does not fully reflect this shift. This bill will actually capture the Financial Crimes Unit's expanded work, provide the necessary authority to respond to various types of financial fraud, such as check fraud, unauthorized electronic funds transfers, and fraudulent payment methods. This legislation will help protect Texans from emerging financial threats and ensure the state remains proactive in the fight against financial fraud.
Members, any questions? Senator Huffman, you're recognized.
Senator Nichols, I think this is a great bill. I'm glad we're expanding this to cover more crimes. I'm going to tell y'all just a quick story, and I want someone from the center to tell me if they would investigate it. So, several years ago, my mother, who just had her 100th birthday yesterday, she was in her 90s, and at the time, my son, who would not been the kind of kid who was arrested. Anyway, he's now a JAG officer in the Army, so all's good. But she got a call from someone saying that my son had been arrested and was in jail, and somehow they knew his name and then told her that she needed to bond him out of jail. Now, why she didn't think, that he wouldn't call, his parents or whatever, I have no idea, because she was in her 90s. She has a good mind, but she had enough mind to understand that there was a problem. And then they put someone on the phone, and she doesn't hear that great, that acted like he was my son and that he needed help and he was in jail. So somehow they talked her into going to Walgreens, and they have some kind of way to transfer money. And she did $4,000 to these people, transferred $4,000. And then, then later that day she called and she said, well, is Luke out of jail? I said, what are you talking about? But I tell this personal story because this is, by the time we called the police and everybody came and investigated and so forth, but they could never do anything. It was kind of like the money had been transferred overseas by then. They couldn't figure out where it had gone. They couldn't do much to help. But I tell that she felt so vulnerable after that, and so like she was inadequate. It was a very, you don't think about it being victims. Yeah, it was a lot of money. It wasn't the end of the world, but what it did to her and her self-confidence and just being able to handle her own affairs was pretty devastating.
That transfer was probably done on one of the crypto ATMs. I'd never heard of that until about 6 months ago, and then I saw one. I was in a grocery store. Mm-hmm. I said, this is what I've been reading about.
Okay.
And you start seeing them all over the place.
Right.
So they put in their credit card or debit card, and then it converts it to crypto, and it's gone. It could be in Hong Kong.
Right. So I say this because there are a lot of Texans that are probably, going through things like this, and we don't even understand the magnitude of it because a lot of people are embarrassed by it, right?
The difficulty, let's back up to the skimmers and see how this thing expanded. Most of your district attorneys and courts are not set up to really understand how all that works. And so that's why they were created.
Right.
And, you really ought to come tour that thing sometimes. It's absolutely amazing. I was shocked. In the unit, when I went, and we took the lieutenant governor, had a chance to visit with these people. You can go up and you can see the maps up and down the highway. It's organized. There's schools in Venezuela that teach people how to do this and open up franchises.
Yeah.
And so they have these skimmer operations running up and down the highways, and they don't even have to go back to the pump. They can be across the street, Bluetooth it, and get your data, send it to St. Louis or someplace where they crank out hundreds of thousands of credit cards, and then those go out, and then they get money, and then it goes to Miami, and it goes to Cuba, and it's gone.
So
And-
very sophisticated operations, right?
Right.
Enough so they're even researching people's names and know who the elderly are and figure out their phone numbers and.
Right.
Yeah.
Captain Headley works there. He could probably explain a lot more of it. But what they've learned to do is actually track these crimes down and put people in jail.
Well, that'd be good.
And so as they do it, they find out that not only is it fuel pump skimmers, it's in ATM machines and other point of sale machines where they swipe your card. And now we're kind of going to the next level, working with the debit cards. You end up working with the bank. That's why a lot of bankers are in the room interested in this. And check fraud, and it just kind of doesn't stop. But they become an expert, and they're training other units in Texas. I'll talk about the budget, but
Yeah.
there was some stuff in the budget related to it. But they're organizing other urban centers and training them how to do the
Good.
same thing. And then other states, this is the only one in the nation, other states are coming to Texas to learn how are you doing this.
Okay.
And so
Right.
this has been a wonderful experience, and it's right down the street from where I live.
Well, good. It's great.
Mr. Chairman.
Nicholas.
Chairman, Senator Hinojosa.
Thank you, Mr. Chairman. And just to follow up on Senator Huffman's comments with the mom, it's really a common practice in South Texas to get a call many times from supposedly cartel people, tell them that they kidnapped your son, your daughter, or your brother, and extort money from that family. Yeah, so it does happen, and unfortunately, more often than we know. But
Thank you. Any questions? Any more questions? So the chair now opens for invited testimony. So Jeff Headley and Jan Mills. We recognize Vice Chairman Parker as present.
Chairman, Senators, thank you once again for allowing myself, Jeff Headley, to be up here before you speaking about this. Senator Huffman, or King, I'm sorry, apologize. Huffman, I apologize. Not in this territory, of course, usually I'm out on the street, but as such, excuse me in that, not knowing everybody's names. But, specifically to your case, I'd be happy to visit with you later today, come by your office and speak to you about it further. But it is something very concerning. It's something we're dealing with often. And if you were to look at the original prescription of what we were formed for in the Texas FCIC, it did not take long for us to realize that we had narrowed our scope too small to deal with the issues at hand. And therefore, instead of, as we formed up, and we have our 16-person team now, which we're very proud of, but 16 people, we've been able to have the impact we have thus far. And we're looking to expand that greatly because the need is really great and the amount of people that we can help. Currently, we were established in 2021 to combat organized crime as it just related to gas pump skimming. We quickly realized our mission needed to be broader, and today, our 16-person team that works with local, state, federal, and international law enforcement agencies to combat a wide range of financial crimes, including ATM skimming, ATM jackpotting, check fraud, wire fraud, and organized crime fraud schemes in general. We are at the forefront of developing cutting-edge technology to combat high-tech crime. We provide investigative assistance to all these agencies, providing criminal intelligence to law enforcement and redacted intelligence to industry as well, such as the banks, the fuel providers, and the other industries that are affected by the crimes that we work to help prevention as well. In an effort to protect the Texas economy and the citizens. In the last 3.5 years, this formula has prevented or recovered almost $300 million in loss. Senate Bill 1499 would simply mandate that we continue to do what we are already doing as we expand our ability to protect Texans, and I urge you to support this bill. And at this time, if you have any questions, I'd be happy to answer them.
Any questions, members? Please proceed.
Hey, thank you, Mr. Chairman and members of the Criminal Justice Committee. My name is Jan Mills, and I'm the CEO of First National Bank of Winsboro. I'm here to testify in support of Senate Bill 1499 on behalf of myself and as current chairman of the Texas Bankers Association. I'd also like to thank Senator Nichols for filing this bill to expand the scope of work of the Financial Crimes Intelligence Center. TBA, as the largest state banking association in the nation, represents nearly 400 banks, with our membership inclusive of banks from the very smallest to the largest asset size in Texas. As TBA's chairman, I've toured all over our state, met with hundreds of Texas bankers, and heard many of the challenges they face. The number one issue reported is financial fraud and the negative impact this prolific crime has on our industry and the families, small businesses, and communities we serve. In Texas, as across our nation, banks are experiencing financial fraud at historically high rates. You can ask any banker from any size institution and geographic location, and you'll discover that fraud is occurring everywhere in epidemic proportions. Some of our Texas banks have even experienced fraud losses that exceed their credit losses in recent years. Our banks are doing everything we can to help stop the fraud, but the bad actors, often backed by large transnational gangs, are working even faster. We need the state's help in combating this crime to protect our customers and the banks that work hard in serving our communities. The FCIC has been instrumental in the fight against financial crimes. Their work in quickly identifying and locating the criminals, stepping in when the federal government can't or won't help, has made a huge and positive impact for our state. We supported the FCIC's creation in 2021 when credit card skimming was rampant across our state. Over the past couple of years, the FCIC's work has increased to include all types of financial fraud. We are in full support of this bill that will ensure the FCIC can continue to expand their work on payment fraud of all types. I've toured the FCIC's facility and witnessed the excellent work and incredible service the center provides to our bankers, including my own staff who are tasked with mitigating payment fraud and losses. The FCIC staff is always responsive and interested in our issues. They provide sound advice and support in recovering our losses. They provide valuable resources to our local and county law enforcement agencies in identifying and pursuing the individuals committing these crimes and the large, sophisticated organizations behind them. The FCIC is having a big impact in Texas and is now a national model for work on financial crime. When TBA made the American Bankers Association aware of their great work, the ABA began to encourage states across our nation to adopt the FCIC model. As usual, Texas leads the way. As an industry, we are grateful for the work of the FCIC, and we are grateful to Senator Nichols and this committee for supporting and expanding their work through this bill. I think you'll see that every dollar invested in the FCIC reaps generous rewards in savings for the crimes that they are investigating and caught, which is money us as banks can turn around and put back into our communities. Thank you for this opportunity to speak with you all today, and I'm happy to answer any questions you may have.
Members, any questions? Thank you very much. Thank you both for being here.
Thank you.
Thank you both very much.
Thank you so much.
Seeing no other invited witnesses on this bill, invited testimony is now closed. The chair now opens public testimony. The chair calls the following witnesses: Desiree Castro, welcome. You have 2 minutes. State your name and your position, and please proceed.
Hi, good morning, Chairman and members. I'm Desiree Castro. I'm the Director of Government Relations for the Texas Food and Fuel Association. Here to testify in support of SB 1499. The Texas Food and Fuel Association, our members own, operate, and supply over 16,000 convenience stores, grocery stores, and travel centers throughout the state. And over the last several years, we have worked to combat fuel theft, and this effort started with addressing card skimming at gas pumps. And the Texas Financial Crimes Intelligence Center, they've been a valuable partner. The work they do, the investigative work, is commendable. Like Senator Nichols said, if you haven't toured the facility, we recommend you do that. We took a tour a year ago, and it was just fascinating to see what they do. They have highly trained agents and analysts. They keep our members informed. They provide industry trends, training, other critical information to help prevent and respond to theft and fraud schemes. So we support this piece of legislation, and we support expanding their scope beyond card skimming to include payment fraud. This will support industry, Texans, and the economy. So thank you to Senator Nichols for working on this.
Any questions, members?
Okay, thank you.
Thank you very much. The clerk will show Senator King is present. Anybody else to wish to testify on, for, or against the bill? Seeing no other public witnesses on this bill, public testimony is closed. Senator Parker moved that Senate Bill 1499 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman,
Senator Huffman?
Senator Huffman,
Oh, aye. Sorry.
Senator Miles, Senator King,
Aye.
Senator Hagenbu. Seven.
There be 7 ayes and no nays. Senate Bill 1499 will be reported to the full Senate with a favorable recommendation. So as a matter of its procedural correction, Senator Huffman moves that committee substitute 1497, Senate Bill 1498, and Senate Bill 1499 be referred to local and uncontested. Is there any objection? Hearing none, so granted. Now we'll go to you.
You gonna go to me?
Yes, absolutely. And then finish out with mine at the end. Chair recognizes Senate Bill 1281. Senator Parker.
Thank you, Mr. Chairman, members. I do have a committee substitute.
Senator Parker offers a committee substitute for Senate Bill 1281. Is there any objection to considering the committee substitute for Senate Bill 1281? Hearing none, so ordered. I recognize Senator Parker to explain the committee substitute for Senate Bill 1281.
Thank you, Mr. Chairman. We'll do so. Mail theft has become a pervasive and costly crime in Texas, affecting individuals, businesses, and financial institutions alike. While current state law criminalizes the theft of mail, it does not adequately address the growing problem of stolen negotiable instruments such as checks, money orders, and bearer bonds, which are frequently altered, counterfeited, and fraudulently cashed. Criminals exploit gaps in the law to steal financial documents from mailboxes, leading to identity theft, financial losses, and significant disruptions for victims. Additionally, organized mail theft rings increasingly now are targeting mail receptacle keys and locks to facilitate large-scale theft operations. Stolen postal keys grant criminals unrestricted access to cluster mailboxes and multi-unit residences, allowing them to intercept sensitive personal and financial information. Despite the severity of these offenses, Texas law lacks a specific statute to criminalize the theft of mail receptacle keys or locks, making prosecution and deterrence even more difficult. Expanding the mail theft statute to include negotiable instruments and creating a specific offense for stealing mail receptacle keys or locks will strengthen protections for Texans against financial crimes and identity fraud. These reforms will reform law enforcement with the necessary tools to combat mail-related offenses and ensure that perpetrators are held accountable. Furthermore, the committee substitute amends the language in 3 key ways based upon the recommendations specifically of law enforcement. First, the definition of mail is expanded to include parcels that are in transit. The current definition does not include mail that is in the process of being delivered by a carrier service, meaning that if the individual stealing the mail is a postal or carrier worker, they cannot be currently charged under this statute. Second, the filed version requires that the person who commits the new offense of theft of mail receptacle, key, or lock must be the person who stole the key or lock. This does not account for those who may be in possession of the key legally, but are illegally copying the key or intending to use it for nefarious purposes. Examples could be a postal worker who copies the key to later steal the mail. CSSB 1281 clarifies this by separating the theft of the key from the other elements. And lastly, 1281, the committee substitute, alters the punishment scale to state that the first offense under section 31.201 will be a third-degree felony, while all subsequent offenses are second degree. This change was also made at the advisement of law enforcement. So again, Mr. Chairman and members, I appreciate the opportunity to come and lay out this bill and appreciate your support for the substitute here this morning.
Members, any questions? Any questions?
I think we got a couple of excellent witnesses as well.
We do. Inviting testimony on committee substitute for Senate Bill 1281 is now open. Chair calls Jeff Headley and George Bearden. Captain Headley can begin, please.
Senators, Chairman, once again, I'm Jeff Headley, captain with the Texas Financial Crimes Intelligence Center. Once again, thank you for having me. The FCIC recognizes the significant impact that mail theft has on individuals and communities throughout our state. This bill addresses a critical gap in our current laws by specifically including negotiable instruments, in other words, checks and money orders, within the scope of mail theft offenses. This amendment is essential because these instruments are increasingly targeted by criminals, leading to substantial financial losses to victims. Furthermore, Senate Bill 1281 acknowledges the heightened vulnerability of disabled and elderly individuals by enhancing penalties for mail theft offenses targeting these populations. And I say that imagining if it's like post office box or a group of mailboxes was in a retirement community or retirement center, and the impact that would have on those individuals. This provision reflects the FCIC's commitment to protecting those most susceptible to financial exploitation. We also note that their tiered penalty structure for theft of negotiable instruments mirrors the graduated penalties for credit card abuse outlined in Section 3231 and 32315 of the Texas Penal Code, ensuring consistency and fairness within our criminal justice system. The bill also takes aim at the theft of mail receptacle, keys, and locks, recognizing that these items are often used to facilitate large-scale mail theft operations. By criminalizing the theft and unauthorized use of these keys and locks, Senate Bill 1281 provides law enforcement with an additional tool to disrupt organized mail theft rings. The FCIC believes that Senate Bill 1281 represents a significant step forward in deterring mail theft and protecting Texans from the financial and emotional harm associated with this crime. We urge you to support this bill and help us safeguard the integrity of our mail system. Thank you for your time, and I am available for any questions you might have.
Captain, thank you for being here. Any questions? Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. And I guess some are just probably information I should know, but you have a statewide jurisdiction, correct?
That is correct, sir.
So when you investigate this type of crime, it'll be the district attorney's office who will prosecute the case.
That's correct. Usually the district attorney office, of course, in the county for which the crime occurred.
Okay. So, but the district attorney themselves or a local law enforcement agency could also investigate this type of crime.
Absolutely.
You coordinate, cooperate, and work with them.
Yes, sir.
But you have the special skills, which is very important. As was mentioned a while ago, many times some district attorney's offices don't have the trained staff to deal with financial crimes. So that's where you come in and really boost their ability to investigate this type of crimes.
Yes, sir. To give a more clear understanding of where we're at in the Texas Financial Crimes Intelligence Center right now, I am one of 3 field agents for the entire center that goes out and investigates cases. I've spent about 3 nights at home in the last 3 to 4 weeks. I'm constantly deployed, constantly in the field, and constantly kicking in doors of suspects that are involved in these organized crime rings.
And when you do that, you get support from local law enforcement.
We do, and we gather these teams together. But one of the things that we're up for this legislative session is hopefully the expansion of our center and the creation of more field offices that involve more field agents like myself that are out there to work with local law enforcement, providing our assets, our expertise, and our tools that we have that you've provided for us to help them, train them in doing their jobs.
Okay, thank you for the work you do. Thank you,
you.
Mr. Chairman.
Thank you.
Thank you. Any questions? Well, it seems like we do need more of you,
Yes, sir.
Mr. Bearden.
Thank you, Mr. Chairman and committee members. My name is Lynn Bearden, and I'm the Chief Lending Officer at Texas Bank, a $2.5 billion state bank with multiple locations across the state, primarily North and Central Texas. It's a pleasure to be here before you. I'm representing the Texas Bankers Association enthusiastically on the substitute for Senate Bill 1281. It's an honor to voice support for this bill and express our appreciation to Senator Parker for filing it. There are a number of reasons for this, but none so important as recognizing that this bill will help protect those that are disproportionately at risk concerning mail fraud, our seniors. As you know, mail fraud in Texas and across the nation continues to escalate despite the best efforts of law enforcement. It's estimated that mail theft-related fraud in 2023 cost Americans around $100 million per month. CBS News reported mail fraud in Texas alone averaged nearly 6,000 cases per year in 21, 22, and 23. Those are only the thefts that are reported to the U.S. Postal Service. At Texas Bank, our customer-facing team members are constantly looking for bogus check transactions. It's no exaggeration to say that there is rarely a day where we don't investigate some type of fraudulent check. Many days, there are multiple reports. Again, those that are targeted are seniors and the most vulnerable of our account holders who still rely upon checks rather than debit cards or other types of digital forms of transactions. These fraudsters use various approaches to capitalize on stolen checks. They'll use chemicals to wash the check amount and change payees. They'll simulate the MICR information to manufacture counterfeit checks, and they will forge signatures on the back of an original check to negotiate that instrument. Last April, one of our longtime customers at our location in Weatherford, a retired school educator, wrote a check that police determined was stolen from the outgoing mailbox at the local post office. In this, at least 2 checks had been washed, one from $25 to $2,500 and another to $8,000. The police investigation culminated in a traffic stop where a bad actor had hundreds of pieces of mail from local residents in his vehicle. In a separate incident, investigators aggressively working the theft of mail from residential mailboxes in Parker County were led to a hotel room in Arlington where hundreds of checks and IDs were discovered. The female perpetrator used chemicals to wash the checks and the fake IDs to cash the checks. Both examples are state investigations that would benefit from the enhanced teeth in the substitute bill for 1281. At TBA banks across the state, it's our highest priority to protect the funds of our customers, and so all of us are constantly educating staff on what to look for in a fraudulent check. I don't need to tell committee members that imaging technology is so advanced that it's becoming harder and harder every day to intercept the bad checks at the teller window or in processing. Since the stakes are higher than ever and the dollars at risk in the tens of millions of dollars annually, it's imperative that law enforcement be given additional tools for enforcement to stop these fraudsters, as is the case with this substitute bill for SB 1281. Enhancing the penalty structure for these crimes on the state level and expanding the definition of what constitutes a serious crime will help investigators and officers across the state be more effective. Thanks again to Senator Parker's leadership and his proactive legislation that we're considering today. I'm happy to answer any questions that the committee might have.
Senator King?
Thank you. George? Sorry, I've known Lynn's Bearden is from Weatherford and is one of the most well thought of citizens in our community in every respect. We go to church together. Been friends a long, long time, and I've never heard him called George. Is that your first name?
It is.
Oh, I'm going to have fun with this. Everybody knows him by Lynn. Okay. No, I was just going to mention that I think my late dad's, who you knew real well, I think one of his checks were found in that Arlington bust as well. Yeah. Wow. Thanks.
I noticed you acknowledged that.
Yeah.
Yes, Senator King.
Anyway, good to see you. Thanks for being here.
Thank you. Any other questions? Thank you all for being here.
Thank you both for being here, gentlemen. Excellent testimony. Thank you.
Seeing no other invited testimony on this bill, the chair closes invited testimony. Chair now opens public testimony. There are no witnesses on this bill. Is there anybody in the public wishes to testify on, for, or against committee substitute Senate Bill 1281? If not, public testimony is closed. Seeing no other witnesses, we'll move on to vote the bill out. The chair moves that Senate Bill 1281 do not pass, but that the committee substitute adopted in lieu do pass and be printed. Clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King.
Aye.
Senator Hagenbu. 6 ayes.
There be 6 ayes and no nays.
That'd be great.
There be 6 ayes and no nays. Committee substitute Senate Bill 1281 would be reported to the full Senate with a favorable recommendation. Would you, Senator King moves that it be that committee substitute Senate Bill 1281 be considered for local and uncontested. Any objection? Hearing none. So granted. Well, with that, I will pass it on over to you.
Chair lays out SB 1300 and recognizes Senator Flores to explain his bill.
Thank you, Mr. Chairman, members. Greatly appreciate your time and effort and the work you all do here in this committee. So organized retail crimes cost Texans millions of dollars in losses every year. This issue has become a huge problem both in our state and nationwide. We studied this issue during the interim and took input from numerous entities, associations, and constituents. It quickly became clear that organized retail theft statute in the penal code needed to be rewritten. The organized retail theft statute was not being utilized as intended. In 2022, the Texas Organized Retail Crime Association estimated a cost of $422 million in stolen goods, which resulted in approximately $21 million in lost state tax revenue. The National Retail Federation asserts that organized retail crimes cost retailers $720,000 per $1 billion in sales. Houston ranks third in the nation in retail crime rates, behind only San Francisco and Los Angeles. To protect Texans from these losses, Senate Bill 1300 addresses the prosecution and punishment of criminal offenses of organized retail theft. The bill seeks to provide a more robust legal framework to deter organized retail theft by enhancing the penalties and clarifying the legal procedures involved in prosecuting such offenses. A person commits an organized retail theft offense if, 1, acting in concert with one or more persons unlawfully appropriates property from a merchant, or 2, on 2 or more occasions within 180 days unlawfully appropriates property from a merchant, or 3, knowingly obtains a benefit from retail theft, or knowingly acts with one or more persons to overwhelm the security response of the store. It specifies that an indictment or information in the prosecution of an offense under Section 31.16 of the Penal Code shall not be held insufficient for failure to name or describe each item of property stolen. It amends Chapter 38 of the Code of Criminal Procedure by adding Article 38.51, which provides definition for merchant and retail merchandise, and establishes evidentiary rules for prosecutions, and amends Section 31.01 of the Penal Code by updating definitions related to retail theft. It also adds criteria for determining the value of stolen property. The bill enhances penalties as follows. a Class B misdemeanor if the total value of the property involved in the offense is less than $100, rather than a Class C misdemeanors if the total value of the merchandise involved in the activity is less than $100. Class A rather than a Class B misdemeanor if the total value of the property involved in the offense is $100 or more than, but less than $750. A state jail felony rather than a Class A if the total value of the property involved of the offense is $750 or more, but less than $2,500. A felony of the third degree rather than a state jail felony if the total value of the property involved in the offense is $2,000 but less than $30,000. 5, a felony of the second degree rather than a felony of the third degree if the total value of the property involved in the offense is $30,000 or more, but less than $150,000. A felony of the first degree rather than a felony of the second degree if the total value of the property involved in the offense is $150,000 or more, but less than $300,000. Or a felony of the first degree punishable by imprisonment of the Texas Department of Criminal Justice for life or any term of not more than 99 years or less than 15, and a fine not to exceed $250,000 if the total value of the property involved in the offense is over $300,000 or more. So thank you for your support, and I'm now happy to answer any questions you all may have.
Thank you, Senator Flores. And members, are there any questions of Senator Flores?
Senator Miles.
Oh, there you go. Senator Miles, you recognize.
Thank you, Mr. Chairman. Senator Flores, I want to thank you for bringing this bill forward. We all know that it's much needed. Crime is on a rampant. But I'm a little worried about the first two levels that would allow the family in need of diapers, formula, or food to be prosecuted at a higher level. I think we can all agree that this bill is intended to go after those who steal for greed and not those who steal for need. Would you say that, Senator Flores?
Senator,
agree with me on that?
Senator, this is a bill that adds additional tools.
Yeah.
So a prosecutor has that discretion to determine if they want to go with the lesser offense of theft, and their discretion is totally there. And yes, the intent of this bill is to go after the organized criminals. And in fact,
that is the intent of the bill, right? Go after the organized
but they
criminals.
still have the flexibility. For you're talking about someone who's gone in there and maybe stolen an item, but they're not. But if they keep on going back with two or more people and they're stealing a whole shelf full of diapers, well then that's organized
scenario.
theft. But the prosecutors still have that option to determine whether they want that discretion. The intent of this is those people that are going into our communities, like yours and mine, clearing out shelves and outright robbery and making it hard for our own people to be able to have commerce in their neighborhoods. So that's what we're targeting.
I'm glad to hear you say that, and I'm in all support of that. But I have a list. This list of penalties compared theft and retail organized theft as proposed in this bill. It appears that we're simply escalating every penalty by 1 degree.
Yes.
Okay, correct? And if somebody steals 2 containers of baby formula, then they could be facing up to a year in prison. And if we're going to go after the organized, Mr. Chairman, I'm just asking.
Yes, sir.
It's just an ask, Mr. Chairman. I'll ask you and the witnesses the same question. Would you be willing to work with me to set a floor, something like a $200, so that we can draw a line between what would be stealing for need versus stealing for greed?
And I
don't want to get our citizens, as we try to squash the organized crime.
Right.
I wouldn't want to give them a heavy penalty to somebody that's just trying to put diapers on their child or formula.
Thank you, Senator
That's all.
Miles.
And it's just a limit of $200.
It's
just a limit of $200.
Of course, the definition of there's also the definition in which the prosecutors have the discretion, pure discretion on that if they intend or have knowledge that they're acting in concert with others, then then they're going in there as an organized theft. But if you're talking about someone, and of course I'm not condoning theft in any form or fashion.
Neither am I, Mr.
To be
Chairman.
clear,
Neither
and I
am
know
I.
you're not. But I just wanted to make clear. I mean, you shouldn't be stealing in the first place. But in order to qualify for this as the intent of this statute, they're acting in concert with 2 or more. We can look into organized theft. And but the prosecutor still has clear discretion to go either way under this bill.
So can I ask you a scenario, Mr. Chairman?
Please.
So, a young couple who may not have the wherewithal, husband pulls up to the Walgreens, the wife goes in, and she picks up some baby formula and some diapers. That's two people. That's organized, correct?
Well,
Based
sir,
on the terminology.
you still have to have, intentionally, knowingly, intentionally, knowingly that they were acting in concert. So, that scenario can go either way. Again, the discretion of the prosecutor to determine whether that was intentional and knowingly or whether they were a party to the offense. That would be up to law enforcement to prove that case. As you well know, that flexibility is very important.
Okay, let's see what some of the witnesses, their opinion on it.
Please, it'll be good. I'm look forward to hearing it. Thank you for those questions.
Hey, I'm just trying to keep
Thank you.
work with you.
Texas is all about justice.
I know you're trying to process the people who are
Mainly, we're after
greed.
these retail crooks that are hitting our stores and making it hard for our people in our neighborhoods to be able to engage in commerce and to make it a good, safe place.
And I agree with you on that.
Thank you.
Senator Hinojosa.
Thank you, Mr. Chairman. I'm joint author on the bill, and
Yes,
I
sir.
really support and understand where we're going and moving in which direction. The focus is on organized retail theft.
That's correct.
But I guess as I look at the different increases in terms of penalties, with inflation being so rising so fast, it really. I guess my question would be whether or not it would also apply to just one individual that is not involved in organized crime, and it seems that it would.
It's again the definition of for evidence and prosecution, the issues of intent, knowledge, and whether the defendant was acting in concert with one or more persons.
And that's what I wanted to clarify.
Yes. So they're acting in concert with someone else, and generally with an individual. It's as I see the statute and the flexibility of prosecutors is to go after them for what they also on the pecuniary value of the theft. And the penalties are just a matter of deterrence. And I don't know if they're keeping up with inflation as far as in recent memories, but I think that it's a matter of we want to stop or make it hard for organized retail theft rings to operate in our state and cause the damage that they're doing to our economy and our quality of life. We want to make this bill is intended to go after them.
I don't know. Sometimes I think, Mr. Chairman, that we ought to index some of these crimes. Every time I go to HEB and I come out almost every other week, it seems like my bill is higher and higher. But thank you for your answer.
Well, hopefully by putting a dent in those that engage in organized retail theft of HEB and Walgreens and everywhere else that's trying to provide services for our citizens, that we can keep those prices down so it's not passed on to consumers.
Thank you.
And any further questions of Chairman Flores? All right. Hearing none, we'll move on to invited testimony now on SB 13. Invited testimony is now open. I'd like to call Jennifer Tharp and John McCord both to come forward at this time. Great to see you both. Thank you for all you do for Texas and your level of engagement. We appreciate so much. So, Jennifer, I want to go ahead and start with you.
Perfect. Thank you. Good morning. Good morning, Chair, Vice Chair, distinguished members of this committee. My name is Jennifer Tharp. I am the Comal County Criminal District Attorney, and it is my privilege this morning to testify for SB 1300. If at any point you have any questions, I'm happy to stop my prepared testimony to address. And Senator Miles, I do plan to address your questions and appreciate the concerns that you've raised this morning. 5 months ago, I sat here, pretty much the same seat, and talked to you about organized retail theft, and I brought to you a whole slew of problems that, from my perspective, I was seeing as a Texas prosecutor. Issues with the current version of organized retail theft in the penal code, issues with regards to the type of evidence that was being collected, as well as the punishment and whether the punishment currently on the books is appropriate for the crime of organized retail theft. We also discussed some of the tools and resources that law enforcement needed. And one of the reports that I went over 5 months ago came from Capital One's shopping research. It was an article, April of 2024, and it reported and researched across the United States the impact to states of organized retail theft. Specifically, drilling down into Texas, Capital One reported that Texas businesses in 2022 lost $5.9 billion of retail merchandise. What is that impact to the state of Texas? That impact was $372 million of lost sales tax revenue. 5.9 billion retail merchandise stolen, 372 million in sales tax revenue that was lost to the state of Texas. I identified 5 areas that I believed were necessary. 1, revising the current organized retail theft statute, imposing penalties and punishments that would deter the type of organized retail theft, not standard theft. 3, provide evidentiary framework that allows for successful investigations and prosecutions. Also support of the Financial Crimes Intelligence Center, which we've heard some great bills and legislation on that this morning. I came 5 months ago with problems, and I hope today through my testimony in SB 13 to come with solutions for those problems. If it's okay with you, I'd like to kind of walk through SB 13 by section and give you some of the reasons and the why there's certain language that's put in that bill.
Please.
Specifically with Section 1, we identify the notice that's required. The notice comes through an indictment or an information. An indictment is for felony offenses, and an information is for a misdemeanor offense. An indictment is the formal charging instrument. In the criminal context, I guess I'll say, comparing it to a civil case, it would be like your civil lawsuit. So giving notice to the person that's been accused of a crime and making sure that the notice is adequate, but also with a common sense approach. We don't need 50-page indictments where I've listed out 467 items specifically stolen from one retail establishment on one day by an organized retail theft ring. So adding some common sense to that. Please understand that the changes do not change the standard of proof. It does not change or shift the burden from the defense or from the state to the defense. The standard of proof that the state bears is to prove each and every element beyond a reasonable doubt. So there's no shift in lowering the type of evidence that's going to be necessary to prosecute these type of offenses. Section 2 lays out the evidence rules. These are the rules of engagement. Again, it's important for the state, for the defense, and for judges to know what type of evidence should come into play. Section 2 lays out that prior theft offenses and also prior organized retail theft cases by the same defendant can come into play and be admissible. Please understand, and I mean no disrespect to my counterparts, the defense bar, but this is the same rules that exist for regular theft. So it is putting in place the same rules for regular theft, which is 3103C3, but it also has it come into play for organized retail theft. If in a case the defendant that I'm prosecuting has a prior organized retail theft offense, that can be admissible to show intent, knowledge, and acting in concert with one or more individuals. And that's what I believe the chair was trying to highlight earlier. Understand these evidentiary rules. It also exists with several other offenses in our penal code to include family violence cases, child sex assault cases, murder, stalking, and Medicaid fraud. I would submit to you, if those priors are relevant for regular theft, it should also come into play for organized retail theft. Further in Section 2, it identifies that unaltered price tags is evidence of the value of the items stolen. Again, looking at it from a common sense perspective, as well as if a price tag has a unique identifying that is showing who the merchant is, that the item stolen was stolen from that merchant with the price tag that it identifies. Moving on to Section 3, it corrects the definition of retail merchandise to include gift cards. We've seen a huge increase in the number of gift cards stolen from retail establishments. It also adds the definition of merchant to be defined as a business that sells items to the public. Section 4, it identifies value, and it discusses what kind of evidence comes into play with regards to value. It identifies with retail theft, value includes the sales price along with the sales tax. And for stolen in organized retail theft, rental items, it is the rental price posted, sales tax, as well as any cost to replace that rental item. Why should sales tax be included? Again, we are talking about retail theft, not just regular theft where it's coming from the owner. When it comes to retail theft, individuals aren't just committing a crime against the retail establishment, they're also committing a crime against the state of Texas. Section 5 discusses the type of manner and means. And Senator Miles, I think this is where some of your questions are coming into. Prong 1 talks about acting in concert with one or more persons if they unlawfully appropriate retail merchandise. Again, and I have to prove this in that case, with the intent to deprive that merchant, the business. Prong 2 is where a person on 2 or more occasions within a 180-day period unlawfully appropriates retail merchandise, money, or other property from a merchant with the intent to deprive that merchant of the property. Again, it's 2 or more times within a 180-day period. Yes, sir?
That happens. If it's just a family, as I described, and they've done it one time, then they're not going to be prosecuted under this bill.
Technically, under Prong 1, it's 1 or more persons. I can tell you as a prosecutor for the last 20 years, in the hypothetical you gave me, that is a theft. That is an offensive theft. But if you'll allow me, I can highlight kind of a distinction on a different type of case, if that's okay.
Okay, I'll follow.
So a case that my office prosecuted was the case of Ruth Mariana Triana. We just finished that case this year. In this particular case, she went into a Kohl's establishment. She stole socks, shorts, sports bra, jacket, leggings, and a tote bag. Initial contact with law enforcement and talking to Ms. Triana, her confession was that she was stealing the items for her children. So an important factor, and I think that was hitting on some of the questions you brought up earlier. However, further investigation into Ms. Triana showed that she had over $200 cash in her wallet, so that would be relevant evidence to look at and compare for law enforcement and a prosecutor in making that charging decision. Is this truly, as I think you eloquently said, stealing for need versus stealing for greed? Also, when you look to Ms. Triana, what was interesting to note is she had 4 prior misdemeanor theft arrests, 1 prior organized retail theft arrest, 8 felony theft arrests, and then 5 robberies.
Okay.
And so I highlight that because when you walk through all 6 sections of SB 13, it's looking at very carefully each and every case. Every case turns on the evidence for it, and every defendant can be completely different. And the important thing with SB 1300 is making sure that as a Texas prosecutor or Texas law enforcement or a Texas retail establishment, we are adequately and carefully addressing the issue. We're not amputating an arm where we can use the tweezers to pull out that splinter in the finger.
Okay. I'm happy to say that you said every case could be different.
Yes, sir.
Because if you, not that case that you just described, but just a simple case of a young pregnant teenage mother, okay, who doesn't have the priors, who just doesn't have the money to buy the diapers. If she falls, will she be held to this law and have to do almost 180 days in jail for a $50 bag of diapers?
So the best way to answer this is, as the chair laid out, Texas prosecutors have discretion. It's interesting because not that long ago, there was a Texas prosecutor in North Texas that pushed out a policy of refusing to prosecute theft offenses under a certain dollar amount. That didn't go over so well. And I will tell you that same prosecutor has walked that particular statement back because every case turns on its own. What else is important with SB 1300 is it incentivizes to prosecutors and gives us that tool for deferred adjudication. Deferred adjudication, and the hypothetical you've submitted to me, number one, that Texas prosecutor may choose not to file it to begin with, number one, by virtue of the need versus greed. Number two, if that Texas prosecutor did choose to file it, they have within SB 1300 the ability to provide deferred adjudication for that first offense. It's the carrot and the stick. For that mother that you just described,
It's arbitrary.
if for that mother that you just described, if she has the opportunity, does not continue in that same pattern, because here's the deal.
Right.
If that mom keeps going in there and stealing items, she's going to jail
get
and
that.
no one is there with her
I
children.
get that. But if it's a one-time deal, I don't want that child, that young mother, to have to do 180 days for a $50 bag of diapers that she stole out of need, not greed. I'm all in support. Look, in my community, the Walgreens are shutting down, the grocery stores are shutting down, and we just got those, by the way. We haven't always had them. But because of this organized crime, we're having to feel the effects. So I'm in all support of this bill, Senator Flores. But at the same time, Senator King, we have to make sure that we are protecting, we're not overbearing and protecting the scenarios that I've described. And it's only the top two, it's only these top two. Right here, Senator Flores. The only the top two is what I'm trying to work with you to change. I get all this. I'm in full support of all this. Okay? So now I've got to drive 10, 20 miles to get some aspirin. I don't have, because the grocery stores are closing because of the organized crime. So I get it. I feel it. But at the same time, I don't want to have to prosecute somebody that's really is picking up something because they actually need it.
So another
And
important.
it's only the top two that I'm talking about.
Yes, sir.
I want to talk about.
I thought it might be helpful to kind of give the rationale on the values and why you have under $100 and then 100 to 750. Those value ladders aren't just numbers I pulled out of the air. It actually matches the theft value ladder. It also matches the criminal mischief value ladder within the penal code. I will tell you those value ladders have changed throughout the history of Texas. There are a period of times where it was $50 or less, or $500, between $100 to $500. This body, along with your counterpart, has gone through over the years to assess what those value ranges should be. So generally speaking, whenever there is a change to a current penal code offense that deals with a value ladder, the drafters like to, especially Ledge Counsel, likes to make sure there's consistency throughout the penal code. So that is the rationale between under $100 and then $100 up to $750. I appreciate all your concerns. I respect that. And I will tell you, it would be hard-pressed to find a Texas prosecutor that is on a Class B misdemeanor for a mom stealing diapers and formula, throwing them in at the maximum sentence in county jail. And understand with misdemeanors, it goes to county jail. I will also address to you in terms of the punishment range for some of the higher offenses. When it comes to TDCJ prison sentences, understand these are what we call non-3G offenses, not your violent. And so what that means is coming into parole purposes, it's a quarter of a time. A quarter of the time. So even hypothetically on a life sentence, please understand that is 60 years, a quarter of time, and with parole law, you can get good conduct time. Mathematically, you can be paroled in 7 years, 5 months on a life sentence for a non-3G offense. I don't know if I answered your question.
You answered your question,
Okay.
and I understand where you're going. I'm still just concerned.
Yes, sir.
Chairman.
Yes, sir. I think it still has the latitude. It's the absolute latitude of the DAs, and that it doesn't say you shall do this, or so it still has that scenario you described. We're after the big retail crooks, the ones that are victimizing your neighborhood, my neighborhood, it's Senator King's neighborhood, and that's who we're after. The ones that go in there and overwhelm the store and clear the shelves out, and and making businesses trying to get businesses that are needed by our communities but can't function because of being overwhelmed by these organized retail theft gangs. That's who we're after. That's
I
the
get it,
bigger
Mr.
picture.
Chairman. I understand.
And but there's still the
need is there.
flexibility in there, Senator, and I thank you for your humanity and your questions. Is that flexibility is still there, and I would hope our prosecutors, and I believe most do, use that wide discretion they have, because I don't think there's a shall that you shall do this if it's that. So they have the latitude. We're giving them more tools to hit those people that are victimizing Texas.
I'm on board.
Thank you, sir.
Chair now recognizes Senator King.
Oh, thank you. And thanks for your really intelligent testimony. And did I, and I completely concur with the need to deal with this organized theft, but did I understand you say that sales tax is going to be added into value?
In terms of the value, that when you're looking at the value ladder, sales tax could be considered as part of the value. It's not an automatic aspect, but it can be, it can be taken into consideration. Yes, sir.
Okay, just kind of help me. Where's the kind of the reasoning behind that, other than wanting to make it a higher value for higher prosecution possibilities? Because
Please don't be impressed with me. It came from Ledge Council.
okay, well, I mean, when you factor in sales tax, first off, it's different city to city.
Sure.
And in unincorporated areas, it's still stealing the same product, and there's no sales tax. There's no 2 cent added on, so it's going to be different city to city, city to unincorporated, and it's not a loss that has actually occurred yet. The state hasn't lost anything until there's actually a transaction completed. In other words, if you want to prosecute a retailer for not collecting sales tax, it has to be sales tax that they either didn't collect or that they collected and didn't send in. So I'm kind of trying to figure that out.
Those are all very good questions. As I mentioned, that wasn't a part of some of the language that I worked on. And I can tell you for all practice, or in all practice, that's not factored in. However, when looking at the value can be taken into consideration as the impact of it.
Well, yeah, but you mentioned if you catch someone and it's got a JCPenney's tag, and then you're going to say, well, then we're going to presume that the theft was from JCPenney's, but you don't have any idea what city they were in and what the sales tax was. I mean, it just seems like something you're just opening up for a...
I'm so glad you asked that question, because those are often cases I got. Recently, I looked at an organized retail theft case where the theft actually took place at a Dick's Sporting Goods. 2 individuals went inside the store. 1 remained in the vehicle in the parking lot. 2 individuals walk out with handfuls of clothing merchandise. In the back of that vehicle, when this vehicle finally stopped, and it wasn't stopped in a safe manner, the vehicle actually wrecked a T-bone into a lady who was just driving within my community in the middle of the day. But in the back of that vehicle, there were also items likely from, I forget all the different stores. I want to say one was a Burlington Coat Factory, another one was a Bath and Body Works. When law enforcement started looking into all of that, they weren't actually able to figure out which Bath and Body Works store it was stolen from, to know the time period. It was clearly an organized retail theft ring. Now, in terms of punishment purposes, I could put forward with photographs of some of the other merchandise that was stolen. You raised good points in terms of, is the state really out those dollars? No, but that's also assuming we're able to successfully return that merchandise to then be later sold. The questions about baby formula, I actually have a baby formula case in my office right now. And in that particular baby formula case, there was $16,882.35 worth of baby formula stolen from H-E-B and $7,534 worth of baby formula from Walmart. You raise valid points. I don't want to go after that single pregnant mom trying to get formula to feed her kids. However, with the organized retail that we're dealing with right now, we've got rings out there that are stealing formula. And so moms are now having to go online to try to buy formula on the black market just to feed their babies. And so we have to have that careful balance. We want to make sure, again, that we're being strategic, that we're not overreacting. or that we're not underreacting. So I do appreciate all your comments. I didn't mean any disrespect to the questions you were asking.
None taken.
Members, are there any further questions of the witness? Jennifer, you wouldn't mind, just for the record, state your full name and your title and your position on the bill, just for the record.
Jennifer Tharp, Comal County Criminal District Attorney, and for SB 1300.
Very good. Thank you very much. And I think just to clarify again, I think, Senator Miles, I think we all appreciate very much your comments there about that young single mom trying to put food on the table, literally in a situation of that's dire. I think at the end of the day, correct me if I'm wrong, Jennifer, but from my perspective, discretion is really the only way you can take this forward, because if you put it in statute that it's allowed, then it becomes much more pervasive. And I think that's the challenge, and therefore ultimately why you've got to allow discretion as opposed to changing statute. Would that be your professional assessment in that regard?
Yes, sir. And again, I highlight Ruth Triana's case.
But to the point, Senator Tan, we are putting it in statute. It's not discretion. This is in statute.
Well, I understand, but we're simply, in each of these cases, just in terms of real explanation of what's happening.
Right.
It's been left to discretion, typically these prosecutors, right? So.
And the final thing that I'll mention is it currently is in statute right now. Those value ladders that you discussed, it goes from a Class C misdemeanor to a Class B misdemeanor. And so it is in statute. The purpose on changing the punishment ranges is to have a difference between regular theft and organized retail theft. I would submit to you that it should be treated and prosecuted differently. There's a difference between regular theft, simple theft, and organized retail theft.
Thank you.
Thank you very much. Next witness the chair now calls John McCord.
Good morning, Mr. Chairman and members. John McCord from the Texas Retailers Association, here to testify in support of SB 1300. I appreciate the opportunity to visit with you for a few minutes this morning and Chairman Flores' leadership on this issue. I've had the privilege of serving as the executive director for TRA for about 3 years now. Here in Texas, the retail association, or the retail industry, employs about 3 million people, and in addition to being a fairly significant revenue generator for the state, we're also responsible for roughly $90 billion in direct individual income to your constituents. And just like every other major industry in the state, we have our challenges. And one of the most significant challenges that we face, both here in Texas and across the country, is organized retail crime. And we've had a pretty significant discussion this morning about the aspects of organized retail crime, kind of how it works. But there is one thing that I do want to highlight in this, and that there are two terms that we use, and those are organized retail theft and organized retail crime. Both are accurate, and both describe the criminal activity that occurs. But there is an important distinction between those two things. Organized retail theft is the statute that is established in the penal code that covers the actual theft. However, when I'm discussing ORC and when most of my members talk about organized retail crime, they do talk about organized retail crime and not just the theft. And the reason for that, and kind of what we found, is that the crime rarely begins or ends with the actual theft when you're talking about these crime rings. Instead, every time there's an occurrence, there are oftentimes ancillary crimes associated with that. Jennifer mentioned the car accident in an escape. A lot of times we'll have employee safety can be at risk. Other customer safety can be at risk. And, there is oftentimes significant property damage that occurs during an incident like this. So most of the time when we're talking about organized retail crime, it's not just the theft of a product that we are talking about. It is multiple crimes that are associated with that one act. I will also note that the recent study from the National Retail Federation showed that 80% of retailers are also saying that incidents are becoming increasingly violent and aggressive. And I point this out, and Senator Miles, to get to your point that we're not just talking about the one-off theft. We are trying to get to the career criminals, the organized theft rings, and to use the term that you use, the theft for greed and not the theft for need, right? We started working with Jennifer and the DA's Association about 8 months or so ago on this issue, and Jennifer and I have sat on several panels in that time, and I always have the unenviable position to follow her. I have yet to find a way to say, to build on what she says and say it more eloquently. So I'm not going to just continue to repeat a lot of what Jennifer has said. But as she walked through the details of the bill, I do want to note that ORC is a complex issue, and there is not a single silver bullet that's going to fix it all. But what SB 1300 does is it takes a significant stab and is a first shot, and it's the first bill that y'all will hear this session to really try and get at the whole approach of combating ORC here in the state. I want to thank Chairman Flores for his leadership on this, and the DA's Association and Jennifer for the time and the effort that they've put in crafting this. I'm happy to answer any questions that y'all have, and look forward to working with your offices as it moves forward.
Thank you, John. Appreciate you being here. Members, are there any questions here of John this time? Senator Miles?
It will be the same question, the first two columns.
Sure. I can't go from the DA's perspective. What I will say is that you would be very hard pressed in the state of Texas to find a retailer who wants to pursue an elevated charge in that scenario. Theoretically it's possible. In practice, I just don't see it happening.
We're putting it in statute. That's what everybody keep on reminding. We're putting it in statute.
Very good. Members, any further questions of Mr. McCord? Thank you both for being here. Members, we have a resource witness from DPS. If someone would like to visit with the captain that's here, are we good? All right, very good. Seeing no other invited witnesses on this bill, invited testimony is now closed. The chair now opens public testimony. That's a witness. Okay. All right. Chair now calls Kirsten Budwine to testify this morning. Kirsten Budwine. Thank you, Kristen, for being here. We appreciate your testimony. And if you wouldn't mind stating your name and your official title and your position on the bill, and you have 2 minutes to provide testimony. Thank you.
Yes, sir. Thank you. My name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project. Thank you, Senator Miles, first of all, for highlighting your concerns with the potential for this bill to affect lower-level crimes of survival. This is also the basis for my opposition today, opposed to SB 1300. Our main concern is with the potential conflation of ORT and petty theft. The November 2024 ORT Task Force report distinguishes between these two offenses by stating that shoplifting usually involves a lone actor taking items for personal use, while ORT involves a network of people taking large quantities of merchandise. We worry that specifically Section 31.16A2 of the new ORT statute may engulf people acting alone and taking items like baby formula, diapers, or food for their children if done on 2 or more occasions within a 180-day period. This language does not require that they act in concert. This is especially troubling since the report claims that law enforcement, DAs, and retailers sometimes have conflicting notions regarding what defines a crime as ORT. We further emphasize this distinction and urge the committee to reject SB 1300 as it may enhance penalties for impoverished people seeking to survive. Further, we'd like to highlight something we brought up in our interim testimony. The National Retail Federation data that was referenced in the bill's layout has been retracted by the NRT itself. We caution against basing any legislation on data that has been proven false. Thank you.
Well, thank you very much, ma'am, for being here. Thank you for your excellent testimony. Members, are there any questions this time, Ms. Budwine? Senator Miles.
What data did you find in false?
So during an interim hearing, we brought up the fact that NRT had released a report that had false data. They later retracted that data, saying that the data that they put in the report was false.
Do you know that?
And I can share the testimony with the citations that we shared back in, I think it was October or November of last year.
But would it change the structure of this bill?
No, sir. We highlighted that point to say that there's been a lot of anecdotes pointed to about ORT where you see like in the media, there are folks who are like, going in, bashing in windows, that sort of thing. But if we're going to be making legislation, it needs to be based on data. And if we're going to be making legislation in Texas, it needs to be based on data that we're collecting in Texas, not national data that has been retracted. And that was the point of that comment.
Okay. Thank you.
Very good. Members, any further questions? Well, thank you very much for being here today and providing such great testimony. Appreciate you being
Thank
here.
you.
Thank you very much. Is there anyone else wishing to testify on SB 1300? Seeing no other witnesses on this bill, public testimony is now closed. At this time, members, we will leave SB 1300 pending here in committee.
Yes. I want to help you get SB 1300 out. I do want to help you get SB 13 out. Okay, but I'm still concerned. We'll talk about that on the floor today, you and I. Okay, all right. Okay.
Chair now lays out SB 1379 and recognizes Senator Flores to explain his bill.
Thank you, Mr. Chairman. Members, fraud has a significant impact on the lives of Texans and the institutions that serve them and costs the state millions of dollars every year. Senate Bill 1379 increases the criminal penalties for forgery by amending Section 32.21 of the Penal Code. The bill is intended to deter forgery by making the consequences more severe, reflecting the seriousness of the crime and its impact on individuals and institutions. Most offenses will be elevated from a Class A misdemeanor to a state jail felony. The offense is elevated from a state jail felony to a third degree if the offense involves a will, a codicil, a deed of trust, a mortgage, security instrument, security agreement, your credit card, a check, authorization to debit an account at a financial institution or similar site order for payment of money, contract, release, or other commercial instrument. And that is basically is the bill. As we know, we're across the state, we're being hit by fraud. I don't know if every family will probably tell a story how we're getting hit by fraud in one way or another. And this is just a way to increase the penalty from a misdemeanor to a state jail felony to deter that activity. That's basically the bill.
Thank you, Chairman Flores. Members, any questions of Chairman Flores at this time? Hearing none, we'll move on to invited testimony. Invited testimony on SB 1379 is now open, and the chair now calls Kate Decker to testify. Kate, good morning. Good to see you. If you would mind stating your name and your official title and position on the bill, please, for the record.
We want to thank you, Chairman Flores, for your support on all of these financial fraud packages and other members, Senator Parker, Senator Hinojosa especially, for your support on these. Financial fraud has been the #1 complaint of our banks across the state. We represent nearly 400 banks from the smallest to the largest. And this has been the major complaint because it impacts, of course, the customers that these bankers serve, which then impacts the communities that they serve. I do have a banker here to testify on this. I'd like you to hear more of the direct impact of this, but again, we want to thank you for your support and your work on this growing crime.
Very good. Thank you very much. Members, any questions?
No, thank you.
Chair now calls Jeff Headley.
Chairman, Senators, thank you once again for having
Captain, welcome. Thank you for being here.
Thank you. And for what it looks like, hopefully the last time today you'll have to listen to me.
Appreciate you being here.
I appreciate the opportunity. I truly do. I'm going to talk a little bit off the cuff here for a second, just because as people question sometimes why we enhance these statutes. And I will tell you from a guy who's truly kind of involved in the game plan of fighting organized crime on a regular basis. Financial fraud, by and large, is organized crime. Financial fraud, many times nowadays, in the cases that we work, involves transnational crime. That means individuals who come to our country with truly no purpose of not just to get by, but are truly attacking us on all fronts to commit these crimes and to come ahead in commerce as they commit these crimes against us. I will say that in our fight thus far in the FCIC, very proud to say that I have states requesting for me to come speak with them and train them on a regular basis on how to assist themselves in these matters, as the people they are arresting are people and suspects that we have already arrested here in Texas and who are now in their states committing the crimes. And the one question they ask me is, why are they here now? And I would say, because we're doing our job, right? And we could not do that without your support in this type of legislature that helps promote and make a deterrent for them to come to Texas and commit these crimes. As such, you know, forgery is a serious crime. It can have a devastating impact on victims, and it can result in financial loss, identity theft, and damage to credit rating. In addition, forgery can be used to facilitate other crimes, such as fraud and money laundering. The FCIC has seen a large increase in the number of transnational and organized groups of criminals involved in acts of forgery, whether it be for commercial instruments such as checks or false or fraudulent paperwork completed illegally and without consent to change the deed of trust on a piece of property. The level of victimization in this arena has substantially increased as the suspects perpetrating this fraud have become more organized and complex. Many of the suspects that commit these crimes are professional criminals that have no other means of income. Senate Bill 1379 would increase the penalties for forgery, making it a more serious crime. This would send a strong message to criminals that forgery will not be tolerated in Texas. In addition, Senate Bill 1379 would provide prosecutors with more tools to prosecute forgery cases, which would help to protect Texans from this crime. At the FCIC, of course, we support Senate Bill 1379, and we think it would be a deterrent to help Texans as a whole. If you have any questions, I'm available to answer those at this time.
Thank you, Captain. Again, if you want to just state your full name and position, I know your position on the bill, but your title with the FCIC.
I apologize, Senator. Senator Parker, I am Jeff Headley. I'm a captain with the Texas Financial Crimes Intelligence Center, speaking on their behalf today.
Thank you very much. Appreciate your great testimony. Members, are there any questions of the captain at this time?
Thank you.
Thank you very much, sir. Appreciate you being here. Chair now calls Jamie Barud to testify. Jamie, good morning.
Good morning.
Thank you for being here. If you wouldn't mind stating your name and your position with your organization, as well as your position on the bill, that would be great for the official record. Thank you.
Thank you, Mr. Chairman and committee members. My name is Jamie Baroud, and I serve as fraud director for Stellar Bank, which is headquartered in Houston. I have 25 years of experience in banking and fraud management, and today I am testifying on behalf of Stellar Bank and the Texas Bankers Association in strong support of Senate Bill 1379. Thank you to Senator Flores for filing this bill to increase the penalties for forgery. Fraud, particularly check fraud, continues to rise at an alarming rate. The 2024 NASDAQ Global Financial Crime Report highlighted $485 billion in fraud-related losses, with financial institutions absorbing $442 billion. Check fraud alone accounted for $21 billion in losses in the Americas, which is 80% of the total global check fraud loss. Despite the shift to digital payments, check fraud and forgery have surged, with FinCEN reporting a 385% increase since the pandemic. These crimes don't just affect banks, they devastate our customers, our communities, and most tragically, our seniors, many of whom lose their life savings to fraud. The increasing sophistication of fraud schemes makes it even more crucial to enact stronger penalties that serve as a deterrent. At Stellar Bank, check fraud accounts for 66% of our cases. Our fraud investigation team works diligently to identify suspects and file cases with law enforcement, knowing that every potential arrest is a step towards deterrence. Despite advances in technology, fraud prevention and detection remains a challenge. At Stellar, we've recently adopted a proactive approach, leveraging threat intelligence to detect compromised checks and stolen account information to help prevent losses before they can occur. In December of 2024, we identified 75 stolen checks for sale on Telegram, totaling approximately $1.4 million. However, technology alone is not enough. Many fraudsters operate with little fear of significant consequences, which only emboldens them. Increasing penalties for forgery will provide law enforcement and banks with stronger tools to combat these crimes and deter offenders. Beyond technology, customer education is one of the most effective tools in combating fraud. Raising awareness remains a core priority in our efforts to protect our communities and our customers. Historically, financial crimes have been seen as nonviolent and their punishments light, but their consequences are anything but minor. I've seen small businesses collapse, families lose everything, and seniors robbed of their financial security. These crimes destroy lives and can have devastating impacts. Banks, consumers, and law enforcement need the state to act. Increasing penalties for check fraud and forgery is a critical step towards deterrence and justice. Stronger penalties will not only hold criminals accountable, but also send a clear message that financial fraud will not be tolerated. Thank you for your time. I welcome any questions from the committee.
Thank you for your excellent testimony. Members, are there any questions at this time? Appreciate you being here. Thank you very much. Seeing that there are no other invited witnesses on this bill, the chair closes invited testimony. The chair now opens public testimony. Is there anyone here wishing to testify on, for, or against SB 1379? Hearing none, we'll go ahead and officially close testimony, and we will leave Senate Bill 1379 pending. One more. Chair now.
1451.
Chair now lays out SB 1451 and recognizes Senator Flores on his bill.
Thank you, Mr. Chairman, members. I greatly appreciate your time and effort and everything you do on this committee. And so during the interim, we heard numerous concerns about the increase in all forms of theft, including various fraud and forgery schemes. Senate Bill 1451 addresses the issue of theft and fraud involving checks. The bill simply enhances the criminal penalty for the offense of stealing or receiving a stolen check. The bill amends the penal code to elevate this offense from a Class A misdemeanor to a state jail felony, and that's the bill.
Thank you, Mr. Chairman, for your layout of the bill. Members, are there any questions of Senator Flores about the bill? Hearing none, we'll go ahead and move on now to invited testimony on SB 1451, which is now open. And I'd like to call Jessica Palash to testify. Thank you, ma'am, for being here. If you wouldn't mind stating your name and your position and affiliation for the record, please.
Thank you, Mr. Chairman and committee members. My name is Jessica Palachi, and I'm the Chief Customer Experience Officer at First National Bank Texas, which is headquartered out of Killeen, Texas, and we operate over 300 locations throughout the state. I am here on behalf of my bank and the Texas Bankers Association to testify in support of Senate Bill 1451. Thank you to Senator Flores for filing this bill to increase the penalty for check theft. In recent years, check fraud has surged, up over 400%, which has significantly impacted the safety and soundness of banks by increasing financial losses, operational strains, and reputational risk. The growing sophistication and speed of fraud schemes, such as check washing, mail theft, and counterfeit check creation, have made it more difficult for banks to detect and prevent fraud in real time. The rise in organized crime involvement in the use of digital channels to quickly cash or deposit fraudulent checks have escalated the speed and volume of fraudulent activity, putting additional pressures on banks, resources, and risk management frameworks. To combat the increase of check fraud, we, as bankers, have committed resources to help address this criminal assault. We have made technology investments, such as the deployment of Positive Pay, which is a fraud prevention service where, in partnership with our commercial customers, they provide a list of authorized checks which the bank utilizes to block unauthorized or altered checks. Through this partnership, we together seek to identify and prevent this criminal activity. Educating both our customers and our employees has been an important tool to combat check fraud. Raising the awareness on how to detect and prevent fraudulent check items to avoid their negotiation has been an important deterrent. Despite our educational efforts, our customers still fall victim. One customer, an elderly veteran, fell victim to these fraudsters. He was targeted through a technology support scam, which is a criminal perpetrating as a technologist that had identified a compromise on his personal computer browser and offered to provide assistance to help our customer. Our customer engaged and provided all of his personal information to include his bank account and routing number, which allowed the criminal to create checks, which he proceeded to fraudulently negotiate throughout several markets across Texas, further spreading the financial loss to the local businesses that accepted these fraudulent items. Within a matter of days, this criminal had stolen over $80,000 from our customer. These criminals were relentless and continued to target our customer for months. Our bank security teams and customer experience teams were able to finally cease these attacks by working closely with our customer each time the criminal tried to regain his new account information. Banks seek increased penalties for check fraud from the state to strengthen deterrence and reduce financial losses. Check fraud can be difficult to prosecute effectively because existing penalties may not reflect the severity of the crime or provide enough incentive for law enforcement to prioritize these cases. By increasing penalties, the state would protect customers and businesses and lower the financial losses, as banks often absorb the financial impact of check fraud, so stricter penalties could reduce the overall occurrence and associated costs. Enhanced legal consequences would make check fraud riskier and less attractive for criminals, supporting banks' existing fraud prevention efforts and protecting our customers. Thank you for the opportunity to speak with you today. I'm happy to answer any questions the committee may have.
Mr. Chairman.
Thank you for your excellent testimony. Chairman Hinojosa has a question.
Thank you,
Recognized.
Mr. Chairman. You know, and as I listened to your testimony, what's really amazing to me is today's technology. About 2 years ago, we actually wrote checks during the campaign to pay for certain services. But they took one of the checks that we used to pay for services, and copied the check, identical check, and they were able to go to the bank and cash it. Of course, the bank didn't debit our account after we discovered it, but it's very difficult to keep up with the improvements, quite frankly, that are being made in technology that allows people who have crime on their minds to be able to manipulate legitimate checks and business transactions. So I'm pretty familiar with that scam that's used, and it's just amazing because you pay to a legitimate business, and somehow it ends up the same check, identical. They just, I guess, manipulate the date and the amount of money and who it's made out to and get it done. So it's a serious issue.
Yes, sir, very much so.
Thank you, Senator Hinojosa. Members, are there any further questions here of the witness? Thank you for your testimony. We appreciate you being here. Chair now closes our formal invited testimony, and now would like to open up public testimony. Let's see if we have anyone that pops up. Is there anyone here wishing to testify on, for, or against SB 1451? Seeing none and hearing none, we officially close testimony here on this bill. We'll go ahead and vote them out. All right. Senator Flores moves that SB 1451 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
5 ayes.
There being 5 ayes and 0 nays, SB 1451 will be reported to the local and consent calendar.
I can't make. These two, the other one was on the floor. Higginbotham.
Chair recognizes Senator Higginbotham.
Yes, I move for it to go to local and consent.
Very good.
Any objection?
Any objections? Hearing none, it's so ordered.
1379.
Senator Flores moves that SB 1379 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu.
Aye.
There being 5 ayes and 0 nays, SB 1379 will be reported favorably to the full Senate.
Local.
Yes, I move to put it on local and consent again.
Any objections? Hearing none, it's so ordered. Senator Flores moves that SB 1451.
1300.
Sorry, 1300. Yeah, apologies.
Floor. Yeah, we're gonna do it and go to the floor with it. Not local. We will go to the floor. Oh, no, we're gonna move, we're not gonna go with local. I'm not gonna ask if I get the unanimous.
Please understand, we need the bill.
Yes. Oh, no,
I think
no.
it just needs to be altered at the top.
That's why I'm gonna ask to go to the floor instead of local and contested.
We need the bill, Jim Chan.
Understand. Senator Flores moves that SB 1300 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
There being 5 ayes and 0 nays, SB 1300 will be reported to the full Senate with a favorable recommendation.
Thank you. Well, members, I have motions in writing from Senator Huffman on Senate Bill 1300, 1379, and 1471, 1451. I have a motion in writing from Senator Parker on Senate Bill 1497, 1498, and motions in writing from Senator King, 1281, 1300, 1379, 1451, 1497, 1498, 1499. They do not affect the outcome. And Senator Hagenbu, we have motions in writing from you as well, but they do not affect the outcome at all. So, members, do you accept them?
Yes.
Thank you. Members, is there any other business to come before the committee? Senator Parker moves that the committee stand in recess up to the call of the chair. Thank you, members.